The provision of Part 3rd of our Constitution, which enumerate the fundamental rights, are more elaborate than those of any other existing written constitution relating to fundamental rights and cover a wide range of topics. The Constitution itself classified the fundamental rights under 7 groups as follows: right to equality, right to particular freedom, right against exploitation, right to freedom of religion, cultural and educational right, right to property, right to constitutional remedies. Of these, the right of property has been eliminated by the 44th Amendment Act, so that only 6 freedoms now remain. In Article 19(1)(c) under 44th Amendment, the right falling under each of the 6 categories are shown in the table 5. Another classified that such OBBS inform the point view person to whom they are available. Thus, some of the fundamental rights are granted only citizen. Some of the fundamental rights are granted only citizen. Protection from discrimination on ground only religion, race, caste, sex, place of birth. Article 15. Equality of opportunity in matter of public employment. Article 16. Freedom of speech, assembly, association, movement, residence, and profession. Article 19. Cultural and educational right of minority. Article 30. Some of the fundamental rights, on the other hand, are available on any person on the soil of India, citizen or foreigner, equality before law and equal protection of laws. Article 14. Protection in respect of conviction against ex post facto laws, double punishment and self-discrimination. Article 20. Article 21. Protection of life, personal liberty against action without authority of law. Article 21. Right against exploitation. Article 23. Freedom of religion. Article 25. Freedom as to payment of taxes for the promotion of any particular religion. Article 27. Freedom to attend at a religious instruction or worship in state educational institute. Article 28. Some of the fundamental rights are negatively worded as prohibition to the state. Article 14 says the state shall not deny to any person equality before law. Similar are the provision of Article 51, 15(1), 16(2), 18(1), 20 and 21 and 28(1). There are others which are positively confer some benefit upon the individual. The right of religious freedom under Article 25 and the cultural and educational right under Article 29 first and 39 first. Still, another classification may be made for standpoint of extended limitation imposed by the different fundamental rights upon the legislative power. On the other hand, we have some fundamental rights such as the under Article 21(c), which are addressed against the executive and impose no limitation upon the legislature at all. Thus, the Article 21 simplifies said that the no person shall be deprived of his life or a personal liberty except according to procedure established by law. It was early held by our Supreme Court that a competent legislator is entitled to lay down any procedure for the deprivation for personal liberty, and that the courts cannot interfere with such law on the ground that it is unjust, unfair, or unreasonable. In this view, the object of Article 21 is not to impose any limitation upon the legislative power, but only ensure that the executive does not take away a man liberty except under the authority of a valid law and strict conformity with the procedure laid down by such law. In later cases, however, the Supreme Court has found it difficult to immunize law made under Article 21 from attack of ground unreasonableness under the relevant clause of Article 19(1) or Article 14 and Supreme Court decision show and the increasing inclination in that direction. Second, the other extreme are fundamental rights which are intended to do absolute limitation upon the legislative power, so that it is not open to the legislature to regulated exercise of such right. Right of guaranteed by the Article 15, 17, 18, 20 and 24. The In the between two classes stand the right guaranteed by Article 19, which itself empower the legislator to impose reasonable restriction upon the exercise of these rights in the public interest, though the individual right guaranteed by Article 19 are in general binding upon the both of executive and the legislature. These authorities are permitted by the Constitution to make valid exception to the right within limits imposed by the Constitution, such as the ground in the brief, the security of state, public order, public morality in and the like. Fundamental right a guarantee against state action. All above all above rights are available against the state. It is now settled that the right which are guaranteed by Article 19 and 34 and 2135 are guaranteed against state action as distinguished from violation of such rights by the private individual. In case of violation of such the right by individual, the ordinary legal remedies may be available, but not constitutional remedy. State action in the context must have be understood in the wider sense for the interpreting the words state wherever it occur in the part of fundamental rights. A definition has been given in Article 20 which says that the unless and legislative organ of the union, unless the context otherwise required, the state will include not only the executive and legislative organ of the union and the states, but only local bodies such as the municipal authorities as well as other authorities. This latter expression refer an authority or a body of person exercise the power of issue of order, rules by laws or a regulation having the force of law is a board having the power to issue statutory rule or exercising governmental power. Even the act of a private individual may become an act of state if it is enforced or aided by any authorities just referred to. Unaided private minority schools over which our government has no administrative control because their autonomy under Article 31 of the Constitution is not stated within the meaning of Article 12 of the Constitution. The Constitution 93rd Amendment Act, those are 2005, asserting clause 5 of the Article 15 of the Constitution and the Constitution 86th Amendment Act 2002, inserting Article 21A of the Constitution do not alter the basic structure or framework of the Constitution and the declare continuously constitutionally valid. The Right of Children to Free and Compulsory Education Act, the Right of Education Act 2009 is not altered by Article 19(1)(g) of the Constitution. However, the Right of Children to Free Compulsory Education Act 2009, insofar as the applies of the minority school, aided or unaided, covered under Clause 1, Article 30 of the Constitution, is ultra vires the Constitution. Article 21A was added by the Constitution 86th Amendment Act 2002, thus making free and compulsory education to children of the age of 16 to 14 years a fundamental right within the meaning of Part 3rd of the Constitution. It should be noted, however, that there is a certain rights of included in Part 3rd which are available not only against the state but also against the private individual. Article 15 to equality in regard to access and use of palace to public resort. Article 17 prohibition of untouchability. Article 18(3)(4) prohibition of acceptance of foreign title. Article 23 prohibition of traffic in human being. Article 24 prohibition of employment of children in hardship employment. But these provisions of Part 3rd are not self-executory. That is to say, these articles are not directly enforceable. They would be indirectly enforceable only if some is law to give effect to them and such law is violated. It follows that the classification of fundamental right into the executory and self-executory is another possible mode of classification. We have now proceeded to survey of the various fundamental rights in the particular. Article 14 of the Constitution provides that the State shall not deny any person equality before the law or the equal protection of the law within the territory of India. Prima facie, the expression of equality before law and equal protection of laws may seem to be identical, but in fact they mean different things. While equality before the law is a somewhat negative concept implying the absence of any special privileges by reason of birth, creed, or life in favor of any individual and the equal subjection of all classes to the ordinary law, equal protection of the law, Article 14, equality before the law and equal protection of the laws, is more positive concept implying the right to equality of treatment to equal circumstances as well as settled that guarantee to equality before law in a positive concept and cannot be enforced in a negative manner if an illegality or an irregularity has been committed in favor of any individual or tribunal group of individual, other cannot invoke the jurisdictions of court and tribunals to require the state to commit the same irregularity or illegality in their favor of the method of allocation of coal blocks by the government of violates Article 14. The consequence of illegal allocation must follow. The Supreme Court declared allotment of coal blocks by the government since 1993 to 2011 as invalid as the allotment are made I without any objective criteria, second without application of mind, without following guidelines of desired recommendation of ministries or other state government concerned, without assessment of comparative merit and without assessment of applicant requirement which is capacity of block to be allotted. Natural resources constitute public property, national assets, and while distributing them, the state is bound to act consistent with the principle of equality and public trust and ensure that no action be taken may be detrimental to public interest. The grant of license of bundle with the spectrum ex facie arbitrary, illegal and violative of Article 14 of Constitution. The concept of equality, equal protection of law, it is a proper spectrum encompasses of social, economic justice in political democracy. Principle of equality is the essence of democracy and according to a basic feature of Constitution. Equality before law. Equality before law, as a student of English Constitution law now, is the second corollary from the Dicey concept of rule of law. Equality before law is correlative to the concept of rule of law for all round evolution of healthy social order. The doctrine of equality before law is necessary corollary to the concept of the rule of law. It is a declaration of equality for all persons within the territory of India, implying thereby the absence of any privilege or favor of any individual. It means that the no mean of above the law of the land and the every person, whatever is be rank of status subject to the ordinary law and amenable to the jurisdiction of the ordinary tribunal against every citizen from the Prime Minister down to humblest peasant in under the same responsibility of every act done by him without the lawful jurisdiction. In this respect, there is no distinction between the official and private citizen. It follows that the position will be same in India, but even the England, certain exception of recognized in the above rule of equality in the public interest. The concept of equality before law does not involve the idea of absolute equality amongst all, which may be physical impossibility. Article 14 guarantees the similarity of treatment and not identical treatment. Article 14 does not require that the legislative classification should be scientifically or logically perfect. A person should be treated equally only if the person was treated worse than other, and those other must be those who are similarly situated to the complainant. Classification for the purpose of legislation cannot be done with the mathematical precision. Legislator enjoy considerable latitude while exercise its wisdom, taking into the consideration merit, circumstances enriched by the experience and strengthening by people will. so long as the classification can withstand rest of Article 14. It cannot be questioned why one subject was included and the other left out, why one was given more benefit than the other. The concept of equality permits rational and discriminating and discrimination conferred by the special benefit of protection of right to a particular group of citizens for the rational reason and emphasized under Article 14 and implicit in the concept of equality. The right to equality under Article 14 of the Constitution is available against the state. It is cannot be claimed against the unaided private minority school. The exception allowed the Indian Constitution are the President or the Governor of the state shall not be answerable to the court for the exercise of performance of power and duties of the office or any act done by property to the done by him exercise of the performer and those power of duties. No criminal proceeding whatsoever to institute constitution against the President and Governor in court during the term of office. No civil proceeding in which the relief claim against the President or the Governor of the state shall be instituted during the term of office or in the court of respect of any act done or perpetrated to be done by him in his personal capacity, wherever before or the entered upon the office of President or Governor of such state until the expiration of 2 months next before notice in writing has been delivered to the President or Governor. In case may be or left at the office stating the nature of the proceeding and cause of action, therefore the name, description, any place of residence of another of the party whom such proceedings are the instituted and the relief under the claim Article 361. The above immunities, however, shall not bar impeachment proceeding against the President, suit other appropriate proceeding against the Government of India or Government of the state. Beside about the constitutional exception, these will courts remain the exception acknowledged by the Committee of the Nation is every civilized country in favor of foreign sovereigns and ambassadors. Equal protection of laws. Equal protection of law, on the other hand, would mean that among equal, the law should be equal and equally administrative like should be treated alike. Equal protection requires affirmative action by the state towards unequal. By providing facilities and opportunities, the substantive equality and distributive justice are at the heart of understanding of the guarantee of equal protection before the law. The state can be treated unequal differently with the objective of creating a level playing field in the social, economic, and political spheres. In other words, it means the right to equal treatment, the similar circumstances, both in the privileges conferred and in the liabilities imposed by the laws. Article 14 proceeds of the promises that the equality of treatment is required to be given to a person who is equally circumstances implicit of the concept of equality in the concept that the person who are the fact is unequally circumstanced cannot be treated on the par. However, unequal cannot be clubbed. None should be favored and none should be placed under any disadvantage. In circumstances that do not admit of any reasonable justification for a different treatment, thus it does not mean that every person shall be taxed equally, but that person, the same character should be taxed by the same standard. What Article 14 prohibits in the class legislation and not classification for the purpose of legislation. The legislature can classify person for the legislative purpose so as it brings them under the well-defined class. A classification should be justified unless it is a patently arbitrary. If there be equally and uniformly in each group, the laws would not be become discriminated through due to some fortuitous circumstances, some included in a get advantage over the others, but they should not be signal out the special treatment. The classification should not be arbitrary, it should be a reasonable and the best of qualities and characteristics that have relation to the object of relation legislation. But if there are any reasonable basis of classification, the legislator would be entitled to make different treatment. The legislator is competent to exercise its discretion and make classification. The reasonable classification must found in a intelligible differentia, which is distinguishes person or things that are grouped together from those who are left out, or a group of the differentia has a rational access of the object sought to be achieved by the legislation in question. It is for the legislator is to identify the class of people to be given protection and on what basis of protection was to be given. A court cannot be interfere. State was wide discretion in respect of classification of object, person and things for purpose of taxation. Legislator can devise you classes for the purpose of taxing or not taxing, exempting or not exempting, granting incentive and prescribed rate of tax benefit of concession. Thus it is a may exempt certain class of property from the taxation at all, such as the charities, libraries and like, impose different specific taxes upon the different trade and profession. The tax real and personal property is different manner and so on. The guarantees of equal protection, thus the guarantees of equal treatment of person in equal circumstances, permitting differentiation in the different circumstances. In other words, the principle of equality does not mean that every law must have universal application for all persons. Those who not by nature, attainment or circumstances in the same position at the varying needs of different classes of persons often require separate treatment. The principle does not take away from the state of power to classifying person for the legislative purpose. A legislator must has not to deal diverse problem arising out an infinite variety of human relation must the necessary have power of making special law to attain particular object, and for the purpose it should must have large power of selection or the classification of person things upon which such laws ought to operate. In order to be reasonable, a classification must not be arbitrary but must be rational. That is to say, it must not only based on some qualities or characteristics which are the found in all of person grouped together and not in other who are left out. Those qualities or characteristics must have a reasonable relation to the object of the legislation. The reasonableness of a provision depend upon the circumstances obtaining at a particular time and the urgency of the evil sought to control by possibility of the power being urgency of the evil sought be controlled. The possibility of power being abused is no ground of declaring provision violative Article 14. In order into the past of text, two conditions must be fulfilled, namely that first, the classification must be founded in the intelligible differentia, which is the distinguishes those that are grouped together from the others, and two, our differentia must have a rational relation to the object sought to be achieved by an act. It is not possible to exhaust the circumstances or criteria must may accord a reasonable basis of classification of all cases. It depends on the object of a legislation view of whatever has a reasonable relation to the object or a purpose of the legislation. It is a reasonable basis of classification to the person or things coming under purview of enactment. Thus, the basis of classification may be geographical. The classification may be according to a difference in time. The classification may be based on difference in the nature of the trade, calling the occupation which is sought to be regulated by the legislation. Similarly, higher educational classification is a permissible basis of classification for promotion as the nexus with higher efficiency on the promotional post. A case of over classification shall be discriminatory and invalid yet would be violate a provision of Article 14 of Constitution. Thus has been held that in offences relating to a woman adultery now declared unconstitutional by the Supreme Court, see the discussion infra. Women in India may be placed in a more favorable position, however, regard their social status need to protection. See under Article 15 post. In a law, prohibition in would be unconstitutional to differentiate between the civil and military personnel, the foreign national visitors and Indian citizens. They have are not similarly circumstances from the standpoint to lead to a prohibition consumption of liquor. Exemption to the candidate who stood first in the Forest Rangers College from the selection of assistant conservative by the Public Service Commission, it being based of regional classification, is not ultra virus Article 14. धन्यवाद.